Protecting confidentiality of environmental due diligence. In real estate transactions, maintaining confidentiality during environmental due diligence, particularly when dealing with Phase 1 and Phase 2 environmental site assessments, is very important. Understanding how attorney-client privilege and the work product doctrine apply can significantly impact the protection of sensitive information. There are two different privileges. The first one is the attorney-client privilege, and the second one is the work product doctrine. When conducting environmental due diligence, it's crucial to consider whether the work performed by the environmental consultant is protected under the attorney-client privilege or under the work product doctrine. The attorney-client privilege protects confidential communications between a client and their attorney made for the purpose of obtaining legal advice. This privilege can extend to communications involving consultants retained by the attorney in order to provide legal advice to the attorney's client. To ensure that the attorney-client privilege applies, the consultant should be retained by the attorney, not directly by the client. This direct engagement of the consultant by the attorney helps demonstrate that the consultant's work is part of the legal advice being provided by the attorney to the client. However, it's important to note that the privilege may be limited when it comes to scientific data, such as the results of soil samples, groundwater samples, and similar testing, which are considered factual data rather than confidential communications. Work product doctrine protects materials prepared by or for an attorney in anticipation of litigation. This protection can apply to reports and other documents created by environmental consultants if they're prepared with the expectation of potential legal disputes. For work product protection, it is essential to demonstrate that the consultant work was conducted in anticipation of litigation. This is more straightforward when dealing with existing court proceedings or administrative orders. However, in transactional contexts, such as property acquisition, courts may be less likely to extend their work product protection as those engagements often begin before litigation is anticipated. Phase 1 and Phase 2 environmental site assessments are the initial step in identifying potential environmental concerns. These assessments, performed according to the American Society of Testing and Materials standards, involve reviewing historical property uses and conducting a site inspection without testing. That's for Phase 1. While Phase 1 assessments are crucial for due diligence, they do not typically include recommendations for further study unless there is some kind of a potential contamination discovered or the client requests it. If a Phase 1 assessment identifies potential contamination, then a Phase 2 site assessment may be necessary. Phase 2 assessments involve more detailed investigations, including soil and groundwater sampling, in order to determine the extent of any contamination. Here are some practical steps for protecting the privilege when it comes to environmental reports. Number 1, retain the consultants through the attorney. By having the attorney retain the environmental consultant, the work performed can be more easily protected under the attorney-client privilege and the work product doctrine. This arrangement helps demonstrate that the consultant's work is part of the legal advice provided by the attorney. Number 2, draft clear contracts. Ensure that the contract between the attorney and the consultant clearly outlines the scope of the work, fees, and liability limitations. This contract should also specify that the consultant's work is being conducted in anticipation of litigation, if applicable. Number 3, review the reports thoroughly. Before any reports are shared with a regulatory agency or any third parties, they should be reviewed by the attorney. This review helps ensure that the language used does not inadvertently create legal issues and that the conclusions by the consultants are factually justified. Number 4, maintain confidentiality. Keep all communications and documents related to the environmental assessment confidential. Avoid sharing the reports outside the attorney-client relationship to prevent waiving the attorney-client privilege or the work product protection. Number 5, educate clients and consultants. Ensure that both clients and consultants understand the importance of maintaining confidentiality and the legal protections that are available. This understanding helps prevent inadvertent disclosures that could compromise the protections of sensitive information. By carefully managing the retention of environmental consultants and reviewing their work, You can protect sensitive information under the attorney-client or the work product doctrine.